First of all, any come our channel, so I have AGH Politics Avenue. Podcast or training because make headlines. And a jamre na edibi exomo awa any day ya hobraxium. Say any idi can subscribe to the channel amami. Na young queen sim straight away. A A.Boahen trial no. Me no can say shocking piece be a TV epium. We are poor Addo watching. Ajamra or boy in chimu. Men semre. Mesra say young poor Addo watching. I swear. Bra or Jambre now obey Chimu with the guys to Asama making now and AD can subscribe to the channel, share now for friends to answer into me and Kebi. Now happy what me I leave you comment constructively under the comment section. At this point in time, Mr. say Yambo Ingra a year Yensim, A.Boahen, and then lawyer attaching justice slim side. Unia Zimbia PP woman Ajambre now ADB exum.
Court and know what matters have been preserved for resolution, the issues that should be resolved. They set it out. Now, so they go through that process. During this process, Lawyer Atachian was burdened to explain to the court that the matters that are being discussed are matters of national security sensitivity because they offenses that have been spoken about against the accused person are relating to conducts that are very normal and also very particular with national security operations. Atta made that point to the media, he made that point to everyone. That the conduct that is being alleged against Kwabena A.Boahen is conduct that if you go and take national security documentation, processes, money payment and all of that, if you go and take national security stuff from 1993, you will find it there. This is the point that Kwabena A.Boahen's lawyers were making, that whatever you're accusing Kwabena A.Boahen of, that he took money, put in Ghana must go bag, and gave it to somebody, and all of those things, they are concise national security operations everywhere in the world, not just in Ghana, everywhere in the world. Because national security operates ultimately at the behest of the president. The president nominates a national security coordinator or a national security minister who manages it on his behalf. No minister is able to tell national security what to do. Nobody except the president. So for that reason, when national security is conducting their operations, they have the leeway to conduct operations in a certain way, even to circumvent certain rules and regulations, if you like. This is the point Atta was making. And the people said, no, it's not correct. Now, to evidence his point, Atta said, okay, if you are telling me that what Kwabena A.Boahen has done is an outlier, that means it's never happened before. Nobody has done that before. No national security person behaves like that. How can you say that you are Signals Bureau and you are cashing money in Ghana must go back and go and give it to somebody? Then we find that you bought houses 4 years ago. So we think that that's the money you use for the houses. Anyway, Atta told them that if you go and bring any national security operative who operated in Kwabena A.Boahen's role, you will find that concisely that person will behave the same way as you are accusing Kwabena A.Boahen of. The person will do the same thing because that is their work. There's nothing to wrong about it. There's nothing to be accused of about it. There's nothing to lie about it. That is their work. And they said, no, Kwabena A.Boahen is a rogue and he's done this and he's done that and Yoko had so much information and all of that. So, now we get to the details. So they get into court. And then Atta says that, okay, can I have all the documents from 1992 relating to how national security people operate? Can I have it in the court? Because I want to demonstrate to this court that the matters that they are accusing A.Boahen of, it is no offense at all. This is Atta talking to the court. It is the way in which our national security behaves. And we have had many presidents since 1992. So I beg you, J.J. Rawlings was the first president. He had a national security coordinator. Bring his file. John Akuffo was the next president. He had a national security coordinator. Bring his file. Professor Mills had Bawumia as national security coordinator. Bring the things that Bawumia did. Bring it, let's see. Then you had John Dramani Mahama. He had Baba Kamara as his national security coordinator. Bring the things that Baba Kamara did, let's see. Then you have Nana Addo Danko Akuffo. He first had Chairman, then he had Asumeni, who is still with him. Chairman unfortunately passed. Then Kwabena Du-Boahen came in with National Signals Bureau. Brilliant idea, modernizing the national security to create a signals bureau, hive it off from the national security so that it sits in between national security and National Communication Authority. Fantastic idea. Every country will buy into this. That was the brilliance of Kwabena Du-Boahen. Went through the process of drafting the bill with Parliament, including Dominic Ayini, the current Attorney General, put everything together. The bill was passed and he was made the first Director General of the National Signals Bureau. And Atta is saying that if you bring all these people, you will see that their conduct, the way in which they conduct affairs, it is exactly the same as Kwabena Du-Boahen did. How then are you calling him a criminal? How are you calling him a criminal? Atta was burdened to have this evidence. The court said, we can't bring you all that evidence, 92, whatever. We can't do it. Go ahead and make your case. You say you have a case, defend your client. Why are you asking us to bring documents? Atta said, documents that I want to bring to protect my client's interest, that you will not allow me. This one, I have to go upstairs, as they say. So, in his filing the application, Atta was so upset. Where's Atta's picture? Atta was so upset that he decided that he's even asking for prohibition of the judge. He's asking the Supreme Court that this judge, we don't want him anymore. Because every document I say I want, he says I can't have it. So I don't want the judge anymore. So Atta went to Supreme Court with an order to prohibit the judge. If Atta had been successful at the Supreme Court, the judge would have been prohibited and asked to leave. And the Lord Chief Justice, congratulations to him, Mr. Justice Bafo-Boni, the new Chief Justice, would have given us a new judge. But the court told Atta that, yes, we agree with you that when you want documents, it should be brought in. And no determination of evidence must be made except and until the document is now tendered in court. Sremsai wanted a determination of evidence to be made in chambers, as they do it in pre-trial. Let's decide. We don't bring anything to court. The Supreme Court said, no, you have to bring it to court. Whatever document that the accused person thinks is relevant to him, you have to bring it to court. Bring it to court and let there be a determination in the court whether this paper is relevant or not. You can't say that the thing he's asked for is not relevant, so we won't bring it at all. No. The judge said, the Supreme Court said, no, bring it. Bring it and say, what paper is this? It's a white paper. What is the color at the back? It's a blue paper. What is the down? Red. What is written in it? What is written in it is the resignation of Justice D.F. Annan. And the court will say, okay, of what relevance is this? Then counsel who is pushing the argument will make his point. The media will be there. They'll write it down. Counsel against the document being admitted will make his point. The media will be there. They'll write it down. And then the court will have the opportunity to give a ruling on the matter. When the court gives a ruling on the matter, the media will be there. They'll publish it. So it will be transparent. So this application is in order to foster transparency with the criminal process that will make our democracy look like it is a normal 21st century democracy everywhere in the world. Accused persons are allowed to defend themselves everywhere in the world. So it is an important point for our Ghanaian democracy to be seen as a modern democracy, that accused persons who are accused in what people believe is a political circumstance would have the full defense of the provisions of Chapter 5 of the 1992 Constitution and the Courts Act, the Criminal Procedure Act, Criminal Offences Act, Criminal Procedure Act, everything, Act 29, Act 30, 1992 Constitution. The accused person must be able to marshal all the articles in any law that can help him defend himself. Because that is what the criminal justice system of modern countries is about. So the court said that as for paper, you can bring it, and then the relevance will be determined in there. But the court decided that they will not prohibit the judge. So the ruling came in a way in which Justice Sremsai, the Attorney General, has won. Because Attachan wanted the judge removed. And the court said the judge cannot be removed. But the things that Atta is talking about, they are correct. Relevance should be determined inside the court. So they go back to continue the trial. Then a lady comes up. I'll tell you more about the lady. But a lady who is being asked questions. He's a prosecution witness. He works for the Signals Bureau. He was kind of arrested together with A.Boahen and co around the same time. But somehow, she says she'll be prosecution witness. Okay. She comes and she's being interrogated on a document, a statement she made. And then Attachan asked her that, did you make any other statements? She said, yes, she did. The reason why she made other statements came up because the dates on which she made the statement appeared that she may have made the statement after the trial had begun. And that was a bit of a problem, isn't it? So he said, I've made other statements. Then Atta says, bring the other statements. Bring it in. Tell the Attorney General people, they should bring the other statements that she wrote. Judge gives them 4 or 3 days to do so. So, Swamsai and co are not happy about this, the court asking them to bring the written statements of their witness, their own witness, the prosecution witness, the written statements of the prosecution. They should bring it. They are not happy with that, you see. So they file to the Supreme Court and say that, Supreme Court, even though, and now here it says, AG seeks review of Supreme Court ruling blocking disclosures on relevance despite earlier 5-0 unanimous decision in a A.Boahen case. I'm not even sure that GH1 put it well. AG is seeking court orders AG to produce 2 Iyoko withheld statements. So it starts from here. Keep this one for me. So when they go back to the court after Attachan has lost the prohibition application, they bring in prosecution witness. So Atta is interviewing her. And then after the interrogation, Atta asks the judge that I need some documents from her. Then the judge orders. So court orders AG Dominic Ayini to produce 2 Iyoko withheld statements, witness statements, and audio recordings of interrogation in the A.Boahen trial. So the court says Atta is right. If the lady says she's written 2 different statements, produce it and produce the recording. Now, the Attorney General people don't want to produce that, or so it appears. So they file an application to the Supreme Court that, but why is the court asking us to produce this? We won't do it. Then Atta says that, but the thing is in the documents in the Bawumia case. The Supreme Court has filed it. So now Atta argues that, yes, they should be able to come and defend the matter. They are asking the Supreme Court to change the thing and say that witness statements or any documents about whom there has to be an evidence decision should be decided at a pre-trial. It cannot come to the main court. So Atta cannot ask for any documents at this stage. That's what Attorney General people want. What do they want to do with the documents? Whatever Atta wants to ask for, why are they keeping it? This is a Ghanaian that you have accused of something. He says, I haven't done the something. These documents will show that I haven't done it. And you say, no. We can't let you have these documents. So the Supreme Court, in the review application, have added 2 more judges for this particular matter. I'm going to what happened in the court to the lady. That's even more mind-blowing. But on this particular matter, as I wrap up. The Supreme Court has asked for 2 more, has added 2 more judges as they do in a review pursuant to the provisions of the 1992 Constitution. So in a review, they've added 2 more, Justice Kulendi and Justice Tanko. So this is the court panel that made the decision that the relevance of a document must be determined in the court. You can't determine it in secret at a pre-trial. Bring the document to the court. Let the judge see the documents. Let all arguments be made. Let the media know it, that these are the documents that came to the court. And let the media also know the decision of the High Court. And then we can discuss it. You can't say that documents that are to be used for the trial, once it's settled at pre-trial, that's it. Let's settle it there. We can't bring it in court. No, the judge says no. The Supreme Court said no. Whilst they ruled against Attachan that you cannot prohibit the judge, this is what they added. And the Supreme Court is a law-making court. You know that already. I mean, those who understand that. It's a law-making court. So they have made the law by doing so. This is what... okay, let me get back to the judges before I tell them. Let me wrap it up here. So this is Justice Avril Johnson. She's the one who led the panel. I don't know their name. So, okay. So Justice Hone Nugan is there, I believe. There's also Justice Akuffo, and there's Dennis J is the next one. Said Dennis J is this. I know him. Yeah, that's correct. I believe this must be Akuffo. Is that correct? J. Frimpong. Okay, this is Justice J. Frimpong. This is Justice Akuffo. Okay, so you have Hone Nugan, Sir Dennis, J. Frimpong, and Akuffo, and Lovelace Johnson, who chaired the panel on that occasion. These 5 judges gave that erudite decision that an accused person must have the document come to court, isn't it? And so that they can deal with it. This is a paraphrasing of what the judges allowed in terms of the decision that they made. It's a paraphrasing of it. Now, so in the review application, Justice Sremsai is saying that these judges must review that decision. You can't say that we should bring the documents to court. I wonder why he's making that application. But anyway, that application was made. The Supreme Court have heard arguments from both sides. They have added 2 judges for the review. And that is Justice Yoni Kulendi and Justice Amadou Tanko. Now, what's the court going to do on 14th of January? Let's finalize with that one as we congratulate Justice Kulendi. The Supreme Court will, on January 14, 2026, deliver its ruling on a request by the Deputy Attorney General asking the courts to review portions of his earlier decision in the case involving National Signals Bureau boss A.Boahen and his wife, who are standing trial for stealing, money laundering, etc. A.Boahen and his wife had previously filed an application before the Supreme Court seeking to prohibit the High Court judge presiding over his criminal trial. The court dismissed that application, that was Atache's application, clearing the way for the trial to continue. However, in his ruling, the Supreme Court also revised a key aspect of the practice direction on further disclosures, holding that the prosecution is required to disclose materials that are in its possession and connected to the case, rather than materials that are in the possession and relevant as originally stated. I'm happy with the removal of the word relevance. So the Supreme Court is saying that you have to disclose matters in your possession that are connected to the case. It is just the fact that it's in your possession. It doesn't have to be relevant. Just bring it out. So Justice Sremsai wants the word relevance to be removed from that sentence so that the court does not need to be pushed into something that is relevant and therefore bring it. You know, that you see the arguments he's making. He says that it doesn't have to be relevant. Once we've started a trial and you didn't ask for it as pre-trial, it's done, it's finished. He warned that this could lead to practitioners relying solely on possession without considering whether the requested materials bear any connection on the issue of the trial. The Deputy Attorney General urged the courts to restore the word relevance with its ordinary non-technical meaning or replace it with the phrase connected with the matter before the court, insisting that the criminal disclosure regime must require some nexus between the materials requested and the case. Members of the panel, we've told you the members of the panel already. So on 14 January, the Supreme Court will be giving the decision whether the Sremsai has won. If Sremsai wins, it means that Atta cannot come to the court and be asking for documents simply because he wants them. He must have showed the relevance of the documents already in the pre-trial, or the relevance of the documents must be the most important factor for which a request is made. And if the request has already been made, then it has not been granted at a pre-trial, then really that's it. But the court will rule on 14th. Let me have the judges here again, and let's see what is likely to happen on the 14th of January in the court. Let's have a look at it. So these 5 judges ruled unanimously. And so in a review application, you normally add 2. So if we were to assume, without knowing, that the 2 new judges, their lordships will vote against the 5, then you're going to have a 5-2 decision, and the decision will still stand. What is required for the decision to change is that their lordships, the 2 new judges, must, at their conference, be able to swing another 2 from here. So assuming that Justice Kulendi and Justice Tanko have a different view from the 5, and they're able to convince, say, Sir Dennis and Justice Akuffo here, then there will be 1, 2, 3, 4. And then they will come against 1, 2, 3, and it will be a 4-3. So these are the circumstances under which the case can turn around. But as it is now, the winning streak is with Atachia. And he, even though he lost the real decision that he was looking for, which was to prohibit the judge, what he got has actually helped to put the case in a perspective that he seems to like. The ball really is shifting to his court. It would appear so. We don't know how the judge will see it, and the judge is the only decision maker in this matter. We are not the decision makers. But it would appear that the ball is in Atta's court to now kick it. Let's see what happens on 14 January going forward. The main trial itself has been adjourned until February, and that's what I'm going to now. What happened in the court? What did the lady say in answers to questions? How did she manage all of those things? That's the big story I'm going to deal with. Now, it's very, very interesting. And you understand why media in the trial, in the courtroom, is always so important. On these sensitive matters, I think that we should begin a culture of broadcasting them, not necessarily live on TV, but it should be live on some online portal that lawyers can check and look at it. I mean, now there's a law platform and a lot of lawyers, they want news on law, they can check and look at it. So we should be able to institute that. The new Chief Justice should leave that as his legacy. He has 1 year to be Chief Justice. He should institute regular trials which are online and people can see it. Anybody wants to watch it. If it's in the commercial court, you can ask people to pay online to watch it because they are interested one way or the other. But if it's a criminal court that has public interest, you can make it free for us to watch in a constitutional matter. I think that should be done. I think that should be done. But anyway, let me go to text messages and then I will come now to the trial of what happened in courts December 9th, is it 10th, 11th, and 12th? Some 3 days in December, everything that has happened over which the case has now been adjourned to February. We're going to talk about that. A lady came to court. This lady, second accused, came to court, and she had a lot to say. We're going to go to that very soon. It's now 20...
We ain't some who it's impossible channel, so I'm not say, Ojim or Harasenes or Badi and the Adomia. Unia, the Basamba room, na Yasumo Consul, A.Boahen politics.